24A0979, State versus Brendan Riley. Charles Jones for appellant, Brian Steele for appellate.
Good morning, counsel. Mr. Jones, you may proceed when you're ready.
Mr. Chief Justice, and may it please the court, the issue in this case is whether an indictment which shows on its face that it was issued by a grand jury and signed by the grand jury foreperson, becomes not an indictment but an accusation because of a clerical error which misstates the charging authority. So why don't I put this indictment up here?
I think it's a little generous to call it a clerical error.
I'm sorry?
I think it's a little generous to call it a clerical error.
Yeah.
I mean, this is a, I don't know yet what to call it. It's a mishmash. It's really kind of a hybrid document. Do you quarrel with that?
I would submit that it is, in substance, an indictment. However, I agree as far as I would not have written it in that way.
Yeah, because I do think of a clerical error as like, you accidentally left a word in or you forgot to put your comma in. Here, you've got elements of different kinds of charging documents.
Yes. Well, I would actually submit that even though it does say that the district attorney charges and accuses, keep in mind that the only error there is the words district attorney as opposed to grand jury.
That's kind of a big deal. So where in the indictment does it actually say indictment? Where in the charging document does it actually say that the grand jury charges the defendant with anything?
That particular quote is not in there. If I may put it up on...
Isn't that the point of an indictment?
I'm sorry, isn't that what?
Isn't that the point of an indictment, for the grand jury to, to serve as evidence that the grand jury has charged the defendant with a felony?
It is. And while that particular phrase isn't in there, we can look at other elements that this is the indictment here. And the most important element that I would submit is right here, where it says true bill and signed by the grand jury foreman.
It's got the right cover page.
Yeah. It does, and in substance, this is part of the substance of the document. In fact, in venerable case law from this court, that is what makes an indictment, is the fact that it's endorsed by the grand jury. There's evidence here that a grand jury looked at this, that a grand jury...
Well, I mean, isn't there equally evidence that somebody slapped this cover page on something that wasn't an indictment and you had a foreperson sign it? I mean, you could make that argument.
Respectfully, no, and the reason is because of the listing of the charges here. These charges are all specific to this case and lining up with with each individual count.
None of which can be charged by the DA himself, but rather have to be charged by the grand jury, correct?
There are some that can be charged by the DA.
Murder cannot be.
Right, murder cannot be.
Is there any evidence that this grand jury did not meet? I mean, is there any evidence that there was an actual defect in the grand jury proceeding?
No, there's not. And in fact, we can look at this and see that there is evidence on this next page that the grand jury did meet. And this here where it says the grand jurors, and it lists the grand jurors' names, you can see some are crossed out. The alternates are crossed out. I believe a couple of others are crossed out. And as trial counsel explained at the motion for new trial hearing, what that indicates is that there was a meeting, because the people who aren't in attendance, the grand jurors who aren't in attendance at that meeting, their names are crossed out.
So that's 100%, like I buy that 100%. Mm-hmm. Here's the problem. In a normal indictment, what comes after this language, the grand jurors, and lists the names, it then says they charge this defendant with X.
Mm-hmm. Right.
It doesn't say that.
Right, and I can acknowledge, just come right out, I believe that when you have an unfavorable fact, just come out and deal with it. That is an error. There's no question about that.
So we all agree with that. Then the real question is, what do we do with that?
Right. Well, the issue really is what kind of an error is it? Is it an error of form or of substance?
Counsel, actually, let me ask you this. Is this a factual issue or a legal issue? Because the trial court found that the grand jury never charged defendant with any crime. I mean, at the hearing, after hearing all the evidence, the trial court found that. I mean, if this is a factual finding, we review that under the clearly erroneous standard. If there's any evidence to support that, we've got to go with the finding. And so we don't have a indictment in this case if we apply that finding, right?
Right. I would submit that that's the trial court's legal conclusion rather than a factual finding, and it made that conclusion based upon looking at the text of each individual count 1, count 2, where it says the district attorney charges and accuses. That was simply its legal conclusion, is that the import of that is that the grand jury didn't charge.
The only evidence it considered was this document.
Yes.
Yeah.
But that's because did the state present any other evidence that this was in fact presented to the grand jury and the grand jury considered it and this was just some sort of issue with the form of it, but that the grand jury actually looked at this? Was there any evidence presented on that?
No, Justice McMillian, there was no additional evidence. We've simply relied on the face of the document itself.
But the posture of the case before us, forgetting the defects in the indictment, is a partial grant of a new trial based on IAC for failure to file a general demurrer.
Right.
Correct?
Correct.
I mean, we look at this through that lens singularly because that's the only issue before us on appeal, is whether the trial court was correct to grant a motion for new trial based on deficient performance by the lawyer in failing to file a general demurrer.
Correct.
So is this a question about general demurrers or indictments? Because under a general demurrer standard, we're just trying to determine whether or not could the defendant admit all the allegations contained in that instrument, right?
Right.
And still be innocent. We all agree that can't be the case.
That's correct.
So, but that also presumes that there was an indictment, right?
Right. And I would submit that the reason how we concluded it's an indictment is simply by examining the document as a whole. And as I point out on this...
Well, you're really better off just focusing on page 1 that says indictment and says it's a true bill. Once you look at the document as a whole, you have actually a harder case to make that it's an indictment. Since we are talking through the lens of IAC, let's talk about what prejudice looks like here for a second. If deficient performance was failure to file the general demurrer, that can only be prejudicial if filing a general demurrer would have resulted in dismissal of the case.
Right.
What would have happened if a general demurrer was filed to this document? Couldn't the state have just gone and re-indicted the case?
Well, the way the ineffective assistance counsel claim was presented, they're arguing that trial counsel was ineffective for not raising the general demurrer after jeopardy had attached. And that is what they're arguing from Mayo and Heath, that the trial court would have been forced to dismiss the case.
Dismiss with prejudice?
Right, right. And we would submit that that's not true. The trial court would not have had to sustain a general demurrer because...
But if the trial court had been required to sustain a general demurrer, then the case is over and there's no curing the defect?
Correct, under the case law from this court. But a general demurrer would not be appropriate because a general demurrer deals with the substance of the accusations versus the form of the indictment. And we can take a look, Justice White.
Yeah, sorry, I'm really struggling with this point myself because I think I understood your brief to say, look, if you just apply the general demurrer test, this document, whatever it is, it's going to pass a general demurrer because all the elements are there and the law is there. So then my question becomes, well, is this a special demurrer or is it something else? Because it can't be that if you're supposed to bring something in an indictment and you bring it in an accusation, but all of the elements are there erroneously, it can't be that you can only challenge it under a general demurrer. It has to be that there are certain documents that are defective as a matter of law if they're inappropriately used.
Yes, the answer is that it would be appropriate for a special demurrer.
So if on the first page of the form, where the foreperson fills in true
Yes.
to the bill,
Yes.
if the foreperson had not filled in true, would that be the proper subject of a general demurrer? Or would it be a special demurrer?
I think one could argue under Mayo that it would be a general demurrer.
Why does Mayo speak to that?
Why does?
How does Mayo speak to that?
That deals with well, what happened in that case was that the indictment was otherwise defective for some other reason. The defendant wanted to get hurry up and get a trial date. So counsel agreed, just look, we'll throw out this indictment, we'll proceed on an accusation.
So I think Mayo doesn't really inform our question here, because they just did it the wrong way in Mayo. Right? They used B instead of A.
Right.
And our question here is this B or is this A?
Right.
So Mayo doesn't answer our question.
Yes, I understand. The point is that Mayo would not allow an accusation under these, that they would,
But
it voids the,
let's say that Mayo says it's a general demurrer if it's not a true bill. Why isn't this like it not being a true bill? Because the thing that it's lacking is a statement that the grand jury is charging the defendant with anything. Isn't that a necessary element of an indictment?
no, Your Honor, it is.
Can an indictment exist without the grand jury charging the defendant with anything?
It doesn't exist in that way, but what makes it an indictment is the fact that, as you see here, when they say true bill, they're saying, this is true, we, the grand jury, are passing on this, we find probable cause to go ahead with this. The statement, the actual quote, the grand jurors charge and accuse, statute places that squarely in the form of the indictment. And I can point this out here.
And that's because ultimately the grand jurors decided that it was sufficient.
Correct, the majority of the grand jurors.
How do we know the grand jury has?
I'm sorry.
How do we know the grand jury has decided that there was probable cause?
Simply because the grand jury foreperson wrote true bill on it. We have to assume that that's...
But she wrote true bill on some stuff that...
About the district attorney?
Yeah, that the district attorney said he charged. Those don't match.
Well, there would be no need if it was simply the district attorney charging. There would be no need to even have a grand jury deal with it at all. Grand juries don't deal with accusations.
Yeah. I mean, I'm just trying to imagine what would happen if someone had you sign a front page of a contract, but then all the stuff behind the contract was stuff that you didn't agree to, right? You wouldn't make that kind of argument.
No.
And so we're trying to figure out where to go from here.
Is it significant that the next page you have the names crossed out
Oh,
to suggest something happened?
That doesn't necessarily indicate dissent. It just
No, I'm
shows...
saying, is it significant that the names are crossed out, which means something happened with the grand jury, namely they considered the
Yes,
the
something
charges?
happened. There was a meeting at which this particular indictment, this particular document was discussed.
Did the state offer any kind of evidence like, here's the log of the grand juror meetings, like I can show you, because I do think there's this bigger macro question of did the state, and this is sort of the Mayo question, did the state try to use an inappropriate vehicle for charging, right? So it seems like the indicia are that the state tried to use an indictment here, but some stuff got really crossways in the middle. But to support your claim that you actually tried to use the right vehicle and that all the process that is supposed to be afforded happened, that there would be things the state could point to say, look, I know we messed this up on page 2, 3, 4, 5, and 6, but the grand jury met, this is how we know, this is where they were, here are their parking receipts. Did any of that happen?
No, Your Honor, we simply relied on the face of the document itself.
Mr. Jones,
Justice Vincent.
do we need to decide with certainty whether there was merit to this argument that this charging document should have been dismissed, or because this is an ineffective assistance claim, can we say, as we've seen, sort of this is a close, difficult, novel issue. It was not ineffective assistance for an attorney not to have raised it and dispose of the case that way.
Correct. The court could
is
should, I would argue, should address it in that way, through that lens, because the fact that we are here having such a animated discussion about it is not something that the trial counsel at the time could have been found ineffective for. This is really a novel argument to say that this document, which says it's an indictment, which is signed by the grand jury, which is listed a true bill, suddenly becomes an accusation just because of the language in the particular counts. That's
It's a curious argument to be making that a document doesn't become something because of the language it uses, right? I mean, you've acknowledged that this is really, we would not endorse this as a practice for the state.
Absolutely not.
And that this was clearly not the best practice, and doesn't give a lot of confidence in the attention to the state's efforts to prosecute serious felony charges.
correct.
So the question I think Justice Pinson asked, the state's, what would be the state's requested disposition? To say this is okay, this is an indictment, or to say probably got problems, but because we're here at IAC, we're going to dispose of it by saying it's a novel question that wouldn't have been clear in the IAC context?
Well, that would be the most direct way to do it, is simply to say that a novel question, undecided, no direct case law on point, not ineffective. The problem with that is that I'm sure my learned brother at the bar, as soon as the remand, or as soon as the remediator hits the trial court, is going to file a motion in arrest of judgment or some other procedural remedy to bring the issue back. So it's just one of...
Because if in fact it wasn't an indictment, then the court lacked jurisdiction, and
correct.
You get it kicked out that way.
Correct. And I'd like to focus on the purpose, really, behind this grand jury requirement. The purpose of it is to see that someone isn't held to account, held to answer for such a serious charge as murder just on a prosecutor's say-so. The purpose is to make sure that a grand jury looks at it, a grand jury determines that there's sufficient proof or to sufficient probable cause. And I would submit that Mr. Riley got that right.
How confident do we have, the standard the grand jury has is probable cause.
Yes.
What is the standard for us in assessing whether the grand jury actually did that? Because usually when we have a normal indictment, it's plain on the face of the document all the way through.
Right.
When there's a question about whether the grand jury actually did that, as there is here, how confident do we have to be?
I think it's simply looking at the face of the document and seeing.
But isn't that Justice McMillan's question? I mean, didn't the trial court do that and make what looks like a factual finding that the thing does not do what it purports to do?
I would say that again, the trial court did look at it. Instead of being a factual finding, it's more of a legal conclusion, that it's saying...
So whose burden would it be to demonstrate that a document which the state offers to be an indictment is in fact an indictment?
I would argue that it would be up to the others. If it shows on its face, if it's prima facie that it's an indictment, it would be up to the defense to show that, to overcome what we see here. And
If it's not an indictment, is it an accusation?
right. Well, that's the defense argument, is that it's an accusation simply because of that language.
So in a prejudice analysis on IAC, what survives after jeopardy is attached, right? Question of prejudice. Does any of this survive if it's an accusation? Murder wouldn't.
Murder would not. There are...
Judge Newkirk concluded that count 5 would survive.
Right, count
Is that
5
accurate?
possession. And apparently the sentence on that has already been served. That would certainly survive, as well as all of the others that can be accused, if you find it's an accusation. And I'll reserve my minute and a half, if permissible.
Sounds fine, counsel. Thank you.
Thank you.
Good morning, Mr. Steele. Welcome.
Good morning. May it please this honorable court, I am Brian Steele, and I have the honor of representing Applee. The way I looked at this indictment when I did not try the case. When I first read the indictment, I don't see the grand jury charging Applee. So that concerned me, because the way I understand our law is that we require 16 to 23 people to serve as grand jurors to make a finding of whether the person should be held to be indicted or no billed. So as I went through this, I then raised it as an ineffective assistance because I believed that there's no jurisdiction on certain counts. I believe that every count, there are 6 counts except for count 5, have no jurisdiction.
So, counsel, I understand your cause for concern. Do you have any evidence or really belief that the grand jury did not convene as to these counts?
There is no evidence that they did convene on the counts at all.
Is there any evidence that they didn't convene?
The only thing I have is the indictment, where the grand jury, to me, ratified or true-billed the fact that the former district attorney of Fulton County charged counts 1 through 6. That's how I looked at it. And we can call it, this court can call it a complaint, an information, an indictment, accusation. I don't believe the name matters.
So what do you make of sort of the first page and a quarter? The first page and a quarter of the document looks in form like I would expect an indictment usually to look like. It says indictment, it has the counts, it says true bill, it's signed by the foreperson, and then it appears to list grand jurors. What do you make of that, and what should we make of that?
I agree with what you said. That goes to form.
And it's not signed by the DA on the first page, which I think it would have to be if it were an accusation. Is that right?
At the end.
And why wouldn't it be form having the language of the DA included if it's form for the other?
Because it's the person, you always taught that it's the individual counts charge the crimes, not what's alleged on page 1, as Justice Peterman was alluding to. It's what's actually charged, and all those counts are charged, and I believe that's the substance by the district attorney.
So what says you about the part that shows that the foreperson of the grand jury signed it and said true bill, and then the names are crossed out? Does that have any significance?
Not really. I feel like, from a reader, that those grand jurors ratified that Paul Howard, the former district attorney, is making a statement, but that doesn't mean that they ratified it on their own.
What is the significance of the word true? Is that a synonym for charge? I mean, what does the word true mean on that front page? And then signed thereafter by the foreperson.
True goes back to when we had indictments, and it was either going to go forward as a true statement on the charging document, or no, it's not going forward. So to me, I don't put much emphasis on it because I'm wed to, and if I'm wrong, I apologize, but I'm wed to the counts. Because you always taught me that's what matters. Now, there are 2 cases I'd like to bring to the court's attention that were not written in the briefs that I think may, the Court of Appeals, I understand they're not binding, but I think they're important to the court. One is Campbell, or may be important, CAMPBELL versus State. It's 294 Georgia Appeal. 166, it's a 2008 case. I actually did that case in the Court of Appeals of Georgia. I represented this gentleman. In Fulton County, there's a mechanism called a complaint. The complaint is really an accusation. If you look at the complaint and the charges, it's identical to Applee's case. But it says complaint. But what happened was exactly what you were asking on the Honorable District Attorney. The District Attorney, I filed a demand for a speedy trial on the complaint. So it's a little different, but under 177170. And I said that's an accusation, so it's a charging document, so it runs. The district attorney then presented evidence that the court accepted, the trial court accepted, and the Court of Appeals, and said, this complaint is a placeholder. It's solely to get a person who is arrested before a magistrate judge to get bond. It is never intended to be a charging document. So I want to point that out to the court because it may seem bad for me, but I'm just, I have to tell you all the opinions that we have. So I just wanted to let you know, but I believe it's different. Another case which I found fascinating is Pearson, Pearson versus State, 258 Georgia Appeal, 651. It's in Division 2. It's a 2002 case. It's 574 Southeast 2D 820. It's in Division 2, like I said. I think it's closer. So this is Newton County. It's a multi-count indictment, 20 counts. The first count says everything that you would expect to see, that we always see, typically, I shouldn't say always, but 99+% of the time. Grand jurors aforesaid charge and accuse Mr. Pearson. Kidnapping, bodily injury, kidnapping, hijacking, armed robbery, etc. Count 1 is perfect. But count 2 through 20, the prosecutor is charging. So I would say it's an accusation. But what the Court of Appeals found was they said, listen, the grand jury charged count 1. The grand jury, or Mr. Pearson, pled not guilty to the indictment. It was called an indictment on every single page of the proceeding. So that you may think is bad for me, but I wanted to raise it for you. I don't think it's necessarily bad because I wouldn't be here if it said that the grand jury charged anyone. And in Pearson, the Court of Appeals said that does go to form because we have the grand jury meeting, we have the grand jury charging, and then counts 2 through 20 go to form. So if you find that interesting, I just want to raise it to you. But, you know, I think it's distinguishable because I don't have a grand jury charging appellate.
Can you spend a few minutes, and I heard the state's rendition, and I appreciate it, talking about the harm side of the IAC, the prejudice side of the IAC claim. I understand the argument that, well, if you had filed after jeopardy attached, then you'd get dismissal and you'd have, you know, with prejudice. Can that be the right standard?
Yes.
So then tell me, if a demurrer was filed before jeopardy attached, would that be an ineffective assistance of counsel?
If a demurrer was filed before jeopardy attached,
If in this case,
yes.
if in this case, this document's returned,
Yes.
and you file a demurrer on that day, the day the indictment is returned, and the indictment or purported indictment is quashed, wouldn't that be ineffective assistance of counsel?
Absolutely.
Because you should wait for jeopardy to attach.
Yes, that's what you taught us in Heath. I mean,
We
you know,
taught you that?
listen, you can do whatever you want, but that's what, you know, in Heath.
Well, I mean, look, in all seriousness, it sounds like, I mean, typically, diligent attorneys raise claims that are advantageous to their clients. And if you have a defective charging instrument, it is not unreasonable to raise your hand and say, there's a problem here. Your point is, if you say it at that early stage, it's just going to get fixed, and you're going to move on. The contrary view is a little bit of gamesmanship. And is it ineffective to not engage in gamesmanship? I don't know. That's a little bit of a trickier question.
I think it's, please, if I'm wrong, I apologize, State versus Wilson, there's a footnote, I believe, by Judge, I'm going to tell you Mickle, but I may be wrong, but Michael, but where it says, you know, this is gamemanship, and then that's been corrected. This is proper lawyering. So if you don't wait until jeopardy attaches, then this is clearly, to me, a jurisdictional problem. The trial court had no subject matter jurisdiction over appellate, except for count 5. And if I'm right, and if this court agrees, I've made it known, I believe that under statutory, not constitutional double jeopardy, I believe that all charges should have been brought at the same time, and therefore there's a reasonable argument, obviously courts would have to decide, everything's barred. But, as you taught me under Strickland, the second prong, the prejudice prong, is the outcome of this trial. The outcome of this trial. And if you wait till jeopardy would have attached, the outcome of this trial would have been different if it would have been raised by...
Mr. Steele, can we move to the deficiency part of ISC? I guess if you put yourself in the shoes of trial counsel in this case, I know you weren't, and maybe if you were, we wouldn't be here right now, but what argument would you make? You'd make it after jeopardy attached. What argument would you make here? What case law would you rely on? And do you think you'd be able to do so clearly enough that it would have been unreasonable not to make it, right? I mean, we've talked about sort of these different cases, nothing quite on point. I'm getting to the question that I asked your colleague on the other side, which is there something here that was clear enough that it was unreasonable not to have raised it?
Justice Pearson, I don't find this to be so novel. I mean, you read the indictment and you see a murder case. You could go back to Thornton and Weatherbed, and the district attorney charged it. This is not...
But you have a very clear case on if it's not an indictment, then you succeed and it's dismissed. But you don't cite nobody cites a case that clearly explains how we are to determine, is this an indictment or is this an accusation? And I spent a lot of time looking. I didn't find one either. I find, just like you, I found lots of little bits and pieces that inform that decision. But on AAC, it's got to be pretty clear.
You know, you're the court, but you read count 1, 2, 3, 4, and 6, not 5.
Where does your ratification theory come from? It's interesting to me. I had not thought about it as a grand jury ratifying a different document. Is that just sort of your post hoc explanation, or does that come from some kind of case law?
Well, I always,
Intuition?
you know, we don't have to have page 1 or 2 like Justice Peterson said, excuse me, you know, which look like the indictment. We don't need that. All we really need, that's a form. That's a form that the legislature said you should substantially do this is correct. We don't need any of that. The substance of this indictment is in the counts 1 through 6. And to me, I don't see it so novel. I don't see it, you know, for ineffective assistance, deficient performance. Somebody had to read that indictment.
In a sense, the Mayo case that you cite, I think, works against you a little bit here, because that case was about, look, the state really tried to use an accusation against someone when they weren't supposed to. And it really wasn't disputed that they tried to use the accusation. If those were your facts here, I think it would fit much more neatly into that line of cases. Here, we're still trying to figure out as a threshold matter which one it is.
Well, if you're figuring it out which one it is, then the trial court, in my opinion, made a determination factually that should not be.
Is that a factual determination, or is that, like, I mean, there's an argument it's legal, and there's an argument that it's applying law to fact that we would review de novo?
I think it's factual because the state had every opportunity. Once I raised this, the face of this indictment shows that it is not the grand jury's charges. That's how I read it. And if I'm wrong, I apologize. But I cannot, I read this a lot. I cannot get where the grand jury charged any of these counts. And if that's true, if I locked in correctly, then everything else is mere surplusage. It's the form, the substance is there. So the burden then shifted over.
So is that a
to the
special
state.
demurrer, if it's form? Should it be special, not general?
But the substance, the form is the page 1 and 2. The substance, we could admit to this. I could go to trial right now on this case, and I could wait till Jeffrey attached or didn't attach, and I can say you have no jurisdiction. And in my opinion,
Because what you would be admitting to is District Attorney Paul Howard charged you with this.
That's exactly, and he cannot charge me. So I am innocent of those charges.
So coming back to Justice Pinson's question about novelty, it seems to me there are two types of novelty. One is you've come up with a brilliant new legal strategy and legal argument that nobody has ever thought of before. And IAC deficiency doesn't attach to failure to come up with a new novel theory nobody's thought of before. But there's another kind of novelty, and that is somebody made an error below that is so obviously an error that nobody has made that error before that resulted in a published opinion. And it seems to me that when you're in that category of novelty, that's not a category of novelty that precludes deficient performance.
This was not novel. I mean, this court reads indictments all the time. You would not have read it but one time to realize this is very wrong. I mean, this was not novel to me. It's just obvious, actually, to me. So once I realized that this is not an indictment, we could have dressed it up, call it a contract, call the first 2 pages a contract, call it a novel. It doesn't matter what you call it. That's the form. The substance is that the district attorney charged crimes that jurisdictionally the district attorney should.
So everything about the grand jury is just form in your
Yes.
mind? It has no significance whatsoever?
Yes. Unless the state wanted to call the grand jurors and said, did you sit on this? Did you hear evidence? They could do that. I mean, it's privileged, but the court can allow that to happen. I would have no problem. I would not have a case. And the judge asked for that. And there's 0 coming. And here we are. So I don't know why I have the ultra burden. I proved it on what the evidence was. I submitted the indictment. It was already in evidence before the trial court. The trial court read it. He said, I can't believe no one realized this. I mean, it was obvious.
So I know, obviously, this is not this case, but I'm trying to think, okay, well, if we're going to delineate when is something on its face an indictment and when is it not? What about a charging document or a purported charging document that had all of the form of this case, but when it got to the actual counts, it didn't attribute the charges to any entity. It just said, "We, in the name and on behalf of the citizens of Georgia."
Or the defendant is hereby charged.
Or the defendant is charged. Would the form save the substance, or would we, does it have to say the magic words of "we, the grand jury"? I understand that's not your case. I'm just trying to get a sense of, when you say it stood out to you, I want to get a sense of where you think that line is.
I believe the line is in the counts itself. So let's just change the facts very simply. Don't call it an indictment. Remove the 23 grand jurors with the names crossed out. Just remove that. Call it an accusation. And then we're charging capital offenses. But you say in the charge, the grand jurors charge and accuse this person. I would say I'd have the burden of showing that the grand jury did not meet, did not charge. That's what, so I think that the first 2 pages are the fluff. So to answer your question, I don't know if I answered it directly, but I don't think it matters anything in the indictment except...
The counts itself
Yes.
has to say
Yes.
the grand jury.
Yes. Otherwise, we don't know that the grand jury charged the person. In
me
this
ask-
case, actually, the grand jury, I'm sorry, I
I'm
apologize.
sorry, go ahead, Mr. Steele.
No, I guess I'm repeating myself.
If we follow the route that you're telling us, what does that say in the future when someone brings an IAC claim and it's a novel issue? I mean, they couldn't have known about it because it's never happened before to know that that may be a deficient performance. Wouldn't we be setting a path that will take us down a road that we wouldn't want to go as a court?
I don't think you're changing anything because I don't find this to be, I apologize, I don't find this to be novel.
Mr. Steele, what's your best authority for the proposition that the grand jury has to show up in the counts?
That the grand jury has to charge and accuse?
That it has to show up in the specific counts? Your theory is, look, the first couple pages is the fluff, I think, as you said. The piece that matters is the substance, and that doesn't say the grand jury charged, it says the prosecutor. So what's your best authority for that point, that the language about the grand jury has to show up with respect to each individual count?
The Constitution of the United States of America, the Constitution of Georgia that says that a person has the right to be charged by grand jury, the statute in Georgia that says that in certain crimes, I understand it's changed in the, I don't remember, the 80s, 90s, has to be charged by the grand jury, and it's not listed there. You know, if we just want to assume that this is correct, because we do assume that certain things that when they're filed, people do it, jurors follow instructions to strike, etc. But you'd be rewriting this charging document.
So what about the stamp, the file stamp on the front page showing that it was filed in Superior Court? And I'm going to ask a question that reveals my ignorance. Are accusations filed in open court?
Yes.
With the clerk of Superior Court?
No pleading is the pleading until it's filed with the clerk. Just like an order.
In Superior Court?
Correct. Well, if it's not in Superior Court, then the Superior Court wouldn't have jurisdiction. So, I want to.
So an accusation, accusations would contain this exact same file stamp, and the file stamp doesn't really tell us anything about what
An accusation, this to me is an accusation. So the district attorney did this accusation. Somehow, it went to the grand jury. I'm not agreeing that they heard any evidence. The grand jury, somebody put their label on it and a type thing, and the grand jurors, they said, Paul Howard, excuse my language, the former district attorney, found this, and they wrote true, and it got stamped filed. And if that's true, then this is an accusation. And an accusation is a charging document, except for these crimes, certain crimes. Thank you. Thank the Honorable Court.
Thank you, Mr. Steele. Mr. Jones?
Thank you, Your Honors. Let me, in my last 90 seconds, try to give Justice Warren a little bit of that research that she was looking for. And these are just a few of the, as I say, venerable cases. I say venerable because it's a lot better than saying old. They're still good law. What I have starred here, Barlow and Williams, The real entry which is necessary to give the paper authenticity as an indictment by the grand jury is the endorsement of that action upon the paper signed by the foreperson of that body. And here are some other examples of omissions which are stated in the statute as being part of the form, which are
Do
not.
any of these cases include not just an omission, but an affirmative statement that the person charging the defendant with the crimes was not the grand jury?
Right, this is not necessarily, this is not an omission. The point is that the fact that the phrase, the grand jury charges and accuses, is not a magical phrase that has to be in every charge. If the indictment as a whole is obvious what's happening, I don't think that it's appropriate for the court to just regard some text as just fluff and irrelevant, and that's just picking and choosing what part of the indictments. We look at the indictment as a whole, and everything about this indictment, other than that error, says that the grand jury is the one acting.
Thank you, counsel. We appreciate the fine argument. We'll have a decision for you as soon as possible, counsel. Thank you.